The next matter to come before the court is Diane L. Warner versus Diane Evans. Both sides will have 15 minutes to argue. If you're the appellant and you wish to reserve any time for rebuttal, you can reserve up to 5 minutes for rebuttal. If when you get started, come on up. If when you get started, you know you want to reserve some time for rebuttal, let me know. I'm keeping the clock this morning, and I will let you know when you're reaching into your rebuttal time. The court's read the briefs, and we are ready to see who you are.
Okay, thank you. My name is Diane Evans, and I am here today because this is a small claims court case. It's a small case. You're the 9th District Court of Appeals. But the only reason I'm here today, truly, is because I believe that this case has been inherently unfair. I'm appearing before you because the magistrate's decision and the lower court decision just doesn't square up with the evidence and the testimony in the case. One of the issues in the case is the issue of the original lease, the tenant's original lease. And the lower court judge wrote that the plaintiff, or the tenant, was under that lease when I became the landlord in the case. My husband and I had been separated for 4 years. He had been handling the property, and after the divorce, I assumed ownership of the property, and I became the landlord in the case. And the original lease, per the lower court judge, was in effect. And that original lease gave very vast discretion in terms of security deposit deductions. It specifically stated deductions were allowable for cleaning, for damage, for new keys, etc. So it was a very broad lease. But yet in the lower court proceedings, these deductions were not permitted, and it seems unfair to have a lease, a signed lease that specifically states that these deductions were allowed, and then come to go to court and they were not. Second point is in this case, a very large issue centered on what I, as the landlord, knew at the time the tenant began her occupancy. Well, the fact of the matter is the tenant began her occupancy when I had no control over the property. I had no access to the property. I didn't know who the tenants were. I had no keys. And so I was asked during the hearing, the magistrate's hearing, did you specifically know the condition of this property when the tenant moved in? And my answer was no, which I did not. However, what I was not asked was, did you know the condition of the property when you became the landlord, when you assumed ownership of the property? If that question had been asked, my answer would have been a resounding yes. When I became sole owner of the property, I called both tenants, arranged a meeting at the property, did an extensive walkthrough, asked them what needs to be fixed, I made a long list, and I fixed every single thing.
Was Ms. Warner a tenant at the time?
She was the tenant at the time.
You did the walkthrough.
And she did the walkthrough with me. We sat down, we became acquainted, and she told me at that time that because her job was uncertain, that my former husband had allowed her a month-to-month lease, and she asked me that if I would continue that. She said it was the only way she could stay. She said she was a good tenant, she paid it on time, and she kept the house clean. The house was immaculate at that time. I saw the windows, I saw everything there. I went through that house, that unit with a fine-tooth comb. We went through every room. But what happened was that during the lower court, the lower court said that I did not state the condition of the unit when during those proceedings. Well, what happened was this. When I was asked the question, did you know that the condition of the unit prior to, when at the time the tenant moved in, I stated no. And I think, as a layperson, you kind of have a sense that when you're in a judicial setting, you answer a question, and you just answer that question. And that's all I did. I answered that question. Well, the next day, it dawned on me that this was going to come back to bite me. That I needed to state that I knew the condition of the property when I became the landlord. And so I called the magistrate's office and I said, can I submit an amplification to yesterday's testimony? And I was told, no, you can't. You can submit something, but she will not read it. It's too late. And so it felt a little bit like, this game of gotcha, which small claims court shouldn't be like that. And so then, as it came out with the magistrate's decision and the judge's order, this became an issue of what I knew and when I knew it. And I couldn't state that I knew the conditions of the windows. Well, the fact of the matter is I did know the condition of the windows. I did know the condition of the entire unit. And if I had been asked the appropriate question, I would have responded as such. And then and that takes me into the third point. And that's why the facts and the attention to detail are so important, whether it's in small claims or whether it's at any level of the judicial system. If you look, and the record reflects this, if you look at the magistrate's decision on almost every other line of that decision, there is a factual error, and it's documented in the materials that were submitted and the arguments submitted to the courts. And there were substantial material misconceptions and misunderstandings that created a vision and a perception of what happened that day that didn't happen. For example, in one case, the magistrate's ruling said that I had locked myself in the unit and called police. I didn't lock myself in the unit and call police. I think what happened was the tenant called police. The tenant, who was there with another man who was her friend, called police, and there was nobody else besides the three of us. And these people, and it reflects in the record, they were 2 or 3 times my size. And I was in a skirt, which is reflected in the police report, and business attire. And the police were called, and it was stated that I had threatened them with the intention of harm, which was absolutely untrue. But yet, that's what happened. It was the tenant who called the police threatened saying that I had threatened she and her man friend, and that the magistrate wrote that totally the opposite, that I had locked myself in the unit and called police. So that was the extent of the misstatement of fact, so that it created the sense that this magistrate didn't even have a sense of the circumstances and the events of that day. And that's what led, and I would argue, that this lack of attention to detail, to the sense of the questioning, the very questioning. Did you know the condition of the unit when the tenant took occupancy? No. But if there had been careful attention to detail, into the circumstances, into the facts, the only obvious and the only relevant question to ask me would have been, did you know the condition of that unit when you became landlord, when you took control of that property? And the answer would have been a resounding yes. And so that's why this whole case has felt, I felt an inherent lack of fairness, a looseness with of facts and details and circumstances. And that's the only reason that I would impinge on the 9th District Court of Appeals on a matter that is this small. Because from a judicial standpoint, it felt like a major miscarriage of justice that went beyond the scope of this particular set of facts and circumstances, you know, the size of this particular size of this case. And then the only last issue I have is that it also, as a taxpayer, paying, you know, helping contribute to, you know, the legal clinic and the program at the University of Akron Law School, it's just very unclear why I would be charged legal fees to pay directly to this this former tenant when she was represented by legal interns from a tax-supported legal clinic. And that concludes my statement, and I thank you very much for your time and attention. And am I supposed to say now whether I would like to reserve that 5 minutes or after?
You have just under 5 minutes remaining, so you'll have an opportunity to use that time after the applicant has finished their argument.
Thank you.
Your Honors, pursuant to an order of this court, legal intern Justin Burns will be arguing for the appellee this morning.
Good afternoon, Your Honors. May it please the court. My name is Justin Burns, and I appear on behalf of the appellee, Ms. Diane Warner. This is a case about a landlord's failure to return a security deposit to one of her tenants. The question for this court is whether the trial court abused its discretion in denying the objections to the magistrate's decision and ultimately awarding the security deposit to Ms. Warner. The appellant, Ms. Evans' arguments can basically be summarized into two categories. One, that there were factual inaccuracies that are legally irrelevant as to whether or not the deductions from the security deposit were reasonable and appropriate, or second, were instances where the landlord possesses the burden of proof to show a causal link between Ms. Warner's occupancy and the damages alleged. If I may, I would like to take each one of the damages alleged in the appellant's brief in turn. The first being the black matter around the windows. Ms. Evans' own testimony at the trial court undermines her argument. As the transcript reflects on page 53 through 54, there was no evidence as to the condition of the windows at the moment when Ms. Warner took ownership or took occupancy of that apartment. Again, it is the landlord's burden to show a causal link between the damages alleged, here being the black mold between two panes of a window, and the tenant's actions. And as the record reflects, there simply is no evidence between the time when Ms. Warner took possession to the time when she vacated that she caused that damage. Second, there were some arguments over a dirty shelf, or as the briefs describe, mouse strippings. As the transcript reflects on page 44 through 51, that shelf was never used during Ms. Warner's tenancy. In fact, it was just a few feet from the ceiling in a basement. There had been a mouse problem at that unit. Ms. Warner promptly notified the landlord of that problem. It was discovered there was a hole in the basement that likely permitted those mice to enter that basement and cause that damage. But again, there must be a causal link between the beginning of the tenancy, Ms. Warner's actions, and the damage alleged. And the record is simply void of any evidence to show that link existed. Finally, there are arguments over keys. Again, as the record reflects, there is no evidence, and in fact, the appellant, Ms. Evans, concedes that point in both her objections at the trial court level on page 6 and in her brief on page 12, that she had no knowledge of how many keys were provided to Ms. Warner when she took occupancy. Ms. Warner testified, as the transcript reflects, that she turned over the keys promptly, that being a key and a garage door opener. There is no evidence in the record to suggest that there were other keys or that Ms. Warner still possessed keys to justify the withholding of additional funds from that security deposit. It has been argued today over what would control the return of a security deposit, whether it be the lease or the revised code. I direct this court's attention to 9th District case, Wayne Mutual Insurance Company versus Parks. The appellee, Ms. Warner, doesn't argue that parties are not free to contract to their own terms. However, as the revised code states in 5321, .05 and throughout that section, that parties are free to contract to their own terms so long as they are not inconsistent with either the revised code or Ohio law. So while there are several provisions throughout that contract that may or may not apply, those provisions are inconsistent with both the revised code and the holdings of this court. At the end of the day, Your Honors, this is a case about whether or not those withholdings were reasonable. Ms. Warner occupied that unit for a number of years, and that the itemized deductions do not warrant nearly a 100% withholding of that security deposit for damages that the landlord has the burden to show that she caused. She has not met that burden, and it's for that reason that we ask the trial court to be affirmed. If there are no questions, thank you.
Thank you.
I would like to address the question of the 100% withholding. After the walkthrough on that day, I knew there were going to be substantial repairs, evidenced by the photos that were submitted in the evidence. And I went to Ms. Warner that day. She was, this was in the record, and I offered that we split the difference, that I would write her a check that day for half the amount of the security deposit. And she declined. She said she had tenants' rights, and she showed me some papers that she had copied from the internet, and said she could take them to court. And it was after that when she called the police. The second issue is what the gentleman really represented, and that was there was an assumption that because I did not see the unit when Ms. Warner moved in, and my husband had control of the property, that the assumption was that I then did not see the unit when I took ownership. And that's not a reasonable assumption to make. It certainly was not a reasonable assumption to make when I financed significant repairs. The assumption should have been that anyone who's going to do repairs at a unit and going to take ownership of the unit would have knowledge of the condition of that unit. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted on our website and the High Supreme Court website.